Okay, let's dive right into this explainer. Today, we're looking at a genuinely terrifying 1999 Supreme Court of Canada case. It's called Smith versus Jones. In this case, it literally pitted the absolute non-negotiable need for public safety right up against the absolute silence of the law. We're going to weigh the very foundations of our legal system against the immediate, real-world threat of a horrific crime.
So think about this for a second. What would you actually do if you were legally bound to silence, but you held the exact blueprint to a future murder? I want you to drop right into the shoes of a psychiatrist who just heard a chilling, meticulously planned confession. Imagine sitting across from someone who calmly explains exactly how they're going to commit a brutal murder. But there's a massive catch. Because you're acting under the umbrella of a defense lawyer's legal team, the law strictly forbids you from picking up the phone and calling the police. No way around it. That is the exact ethical and legal nightmare that sparked the case we're unpacking today. Section 1. A chilling confession. The blueprint for murder.
So, our story kicks off when an accused man, we'll just call him by the pseudonym Mr. Jones, is sent by his defense lawyer to see a psychiatrist, Dr. Smith. Now, the lawyer assures Mr. Jones, hey, everything you tell the doctor is strictly privileged. But during their 90-minute interview, Jones details a heavily planned, sexually sadistic murder plot. He targeted specific victims, specifically smaller prostitutes in Vancouver's downtown east side. He outlined this horrific toolkit he'd put together: rope, duct tape, and a blue ball to silence them. He'd even installed deadbolts on his basement apartment doors and planned to shoot the victims in the face and bury them in Hope, BC. And maybe the most chilling part? He referred to his previous violent assault as just a trial run. Yeah, Dr. Smith realized instantly this wasn't just idle talk or someone blowing off steam. This was real.
Section 2. The Wall of Privilege. The ultimate legal shield. Dr. Smith knew without a doubt that Jones was a severe, ongoing danger to the public. He was a ticking time bomb. But when the doctor actually tried to sound the alarm, he hit an absolute brick wall, legally speaking. Because Dr. Smith was an expert hired by the defense lawyer to help prep the case, his conversations with the accused were totally shielded by solicitor-client privilege. Basically, talking to the doctor was legally exactly the same as talking to the lawyer. In our justice system, this is the highest privilege recognized by the courts, and it is fiercely, fiercely protected. Now you might be wondering, why on earth does the shield even exist? Well, let's look at history. There's a quote from an 1876 precedent called Anderson that hits the nail on the head. He should be able to place unrestricted and unbounded confidence in the professional agent. You see, our entire justice system relies on the accused being able to be 100% honest with their defense counsel. If you can't tell your lawyer the unvarnished truth because you're terrified they'll just testify against you, well, you can't get a proper defense. The whole system would basically collapse. That's why the privilege belongs entirely to the client, not the lawyer, and definitely not the doctor.
Section 3. The Public Safety Exception. When the shield drops.
But Dr. Smith was absolutely haunted by his silence. When he found out the sentencing judge wasn't going to be warned about Jones's horrific plans, he actually took the extraordinary step of suing. He sued for a legal declaration to break his own duty of confidentiality. It's a massive move. To understand how the Canadian Supreme Court approached this profound dilemma, we have to look at how other places handled it. Take the famous American Tarasoff case from California. In that one, a patient told his psychologist he intended to kill a specific young woman. The court there ruled that psychologists actually have a duty to warn foreseeable victims of a serious danger of violence. They had to weigh treating mental illness against keeping the public safe from violent assaults.
And there's a brilliant quote from the Tarasoff judges that perfectly captures this moral balancing act. The protective privilege ends where the public peril begins. Just let that sink in. The Supreme Court of Canada now had to figure out if they'd apply that exact same logic to the ironclad shield of solicitor-client privilege. Could the ultimate privilege of the defense actually be pierced by the ultimate peril to the public?
Section 4. The three-factor test. Keys to the wall.
Well, the Supreme Court of Canada ultimately ruled that yes, the privilege could be broken to protect innocent lives. But, and this is a huge but, only under incredibly strict criteria to make sure this exception isn't abused. They laid out a really specific three-factor test to drop the shield. First, clarity. Is there a clear risk to an identifiable person or group? Second, seriousness. Are we talking about a risk of death or serious bodily harm? And third, imminence. Is the danger urgent? Does it create a real sense of urgency? All three have to be there.
So let's apply the facts of Smith versus Jones to this new test. It makes it crystal clear why the court acted. First up, clarity. Jones had a specific, identifiable target group,
prostitutes in Vancouver's downtown east side. Box checked. Second, seriousness. His meticulous planning of a sexually sadistic murder easily met the threshold of serious bodily harm or death. And finally, imminence. Even though he was awaiting sentencing, he'd admitted to breaching his bail conditions to go visit the target area. So the threat was clear, it was incredibly serious, and it was absolutely imminent.
Section 5. The Supreme Court ruling. The ultimate test.
Now, here's where things get really fascinating. This ruling actually sparked a deep philosophical divide among the Supreme Court justices. Everyone agreed the danger was severe enough to justify a warning for sure, but they fiercely debated how much information should be revealed. The majority opinion? They prioritized saving innocent lives. They said yes, breach the privilege to reveal both the imminent danger and the specific details of the threat, meaning the confession itself, to the police. But the dissenting opinion pushed back hard. They argued you should protect the privilege by only allowing the doctor to warn of the danger without handing over the accused's actual confidential words. They were totally against conscripting a patient's own confession to incriminate them.
Section 6. The cost of disclosure. A double-edged sword.
And, we really have to carefully weigh this dissenting view. Justice Major gave a stark, honestly kind of chilling warning about the unintended consequences of punching holes in this privilege. Think about it. If a criminal knows that a psychiatric evaluation arranged by their own lawyer could just be handed over to the police, what are they going to do? They'll just stop talking. The dissent argued that this erodes constitutional charter rights to a full defense. More frighteningly, if dangerous individuals refuse to be evaluated, they don't get diagnosed and they certainly don't get treated. We might stop one crime today, sure, but by creating this chilling effect where violent offenders just stay silent, we leave untreated ticking time bombs in our communities. Like the dissent said, it trades long-term public safety for an illusion of immediate security.
And that brings us to the haunting paradox right at the heart of this explainer. The court was forced to choose between the immediate, undeniable terror of an innocent life being taken and the invisible, structural integrity of a justice system that's designed to protect all of us in the long run. So I'm going to leave you with this final provocative thought. Does stripping away confidentiality to save a life today actually risk putting more lives in danger tomorrow simply because criminals stop talking to doctors? It is an incredibly heavy question about the scales of justice, and it's one that our legal system is still wrestling with today.